Hi, Bill Henshaw here, your walking constitution on the San Francisco Peninsula. And I've just done a video on the multi-million dollar default judgment I got. You're all going to love it. And I can help you to do the same thing. Now, are we going to win all our cases? Probably not. But we're going to give them a hell of a fight in doing it. And, the best way to do it is like I did in my unlawful detainer case. I set the unopposed record in the trial court. 48-page unopposed motion. We also had multiple acts of treason in front of multiple witnesses with multiple affidavits. That's what beats the bastards if you did what I did and filed what looks like a 42 U.S.C. 1983 civil rights claim. It's anything but. And pages 2 and 3 fill in the blanks there, and I have some more on jurisdiction and venue as well. That's unique to what it is I do, the approach I have. But I believe the Supreme Court's going to have our backs here because we can prove we don't have any states, no state judicial courts, no known remedies. What that means for you is it almost doesn't matter how long ago that you were injured by government action. You want to go back 20 years, 30 years, maybe longer than that, since either we don't have judicial courts or they're conspicuously concealing them from us so we don't know where to go to get our actions filed. Because I can tell you, people, none of you are in a judicial court, no matter where you are. Nothing remotely resembling that. And that tells you one or two things. Either one, all the laws on the books are null and void as bills of attainder, or two, there are no states remaining which were admitted into this union. The magnitude of the issues is astounding here. And one of my big jobs, if I ever see a jury, which I can't imagine I will, is to make it clear to them what I'm saying here. And I will do my job. And in terms, they'll understand it. And they will also learn they have the power to rule on the facts and the law. That goes all the way back to the Magna Carta in 1215, excuse me. And it was well known by the framers and everybody around the Constitutional Convention. I mean, those things were all there. And that's why things worked out so well in the beginning. It wasn't a perfect government. I'm not saying it was. Only the best one ever invented, when it had that high regard and esteem for human life, the value of human life, no longer exists today. It's out the window. Might as well be robots or what have you. And that's everybody. Everybody says, oh, they put in the 14th Amendment to take care of slavery. Hell no, they didn't. That was a convenient excuse for the government to act. What really happened was they turned all of us into slaves. And that's what has to stop. And you get my materials, by the way. It's the main email, uwinnincourt@gmail.com. I have a brief on the 14th Amendment that absolutely destroys it. Not only it doesn't exist, it never did. And that's the only jurisdiction they have. And that's why I did so well with this unlawful detainer case. And don't be confused there, because all you have to do is substitute whatever agency you want in there, DMV, FTB, CPS, whatever. They're all administrative agencies, and the courts are coming down, especially the Supreme Court, and now the Fifth Circuit, the most conservative court of appeals, is doing that. So we get all our documents set and get the record set. Now we're in great shape because they come into federal court, and what's going to happen to them is what just happened in my case. They can't come in there because they had the sworn duty in the trial court to show up, and they didn't. They, in effect, conceded the correctness of every argument we were making, and there's not a damn thing they can do about it now. And that's how it works. And it will work for you. And even if your record wasn't set like that, as I mentioned, it's constructively set because, one, you didn't have effective assistance of counsel. That's the only right they think we have, limited to a state bar association attorney. Ain't one of them who's never going to raise issues like this. Isn't going to happen. Or two, we didn't learn anything in the mandatory public education system where we should have been taught. I didn't 50 odd years ago, right outside of Washington, D.C., for crying out loud. And I was at the head of the class of ignorance. And I volunteered into the Vietnam War at the height of Marines in the Vietnam War at the height of the Tet Offensive. I mean, talk about stupid. But luckily, Mom put a curse on the Marines and said, "You're not going to get them," and they didn't. Because as you can see, the sergeant looked up and took one look at me and says, "If you lose your glasses, how will you know who to shoot?" In the Marine Corps for 3 hours, shortest tour of duty in the history of the Marines. I've got a better answer. I'll tell you about it in another video for that question now that I know the truth. But fortunately, I never had to go there. But it wasn't because I wasn't as ignorant as all. I mean, I'm embarrassed about that I would be that ignorant. But it is what I mean. They just don't teach us, and that's what they want you to be, and that's what they treat you as. By the way, not principal and agent, guardian and ward. You're going to learn a lot about that, which beats them. I've got it in black and white. Send me an email, uwinnincourt@gmail.com. And we'll be talking about, among other things, the Georgia Probate Code. And there's the functional equivalent everywhere else. They may not do it exactly the same way, but they think guardian and ward. They think we're incompetent and maybe even ignorant from the time they make our first appearance in their quote unquote court. And that's how they think it works. But there's no factual foundation and legal basis for it. And in most of the settings we're dealing with, they're really quasi-criminal, if not criminal anyway. And how in the world, if we're incompetent, could we have the competence to form the intent to commit the crime? Willful acts can't be done. Even better, think about this. If we're incompetent, how is it that we magically regain competence every 2 or 4 years on election day? And you'll learn by getting my materials. Send me an email, uwinnincourt@gmail.com. There's no electorate, there are no elections, and there very arguably hasn't been any elections since 1864. And we may have to go back a little further than that. And that undoes the whole system. Where in the world, if you have no elections and no electorate, where can we find the consent of the governed? It's not there anywhere. A jury is going to see that. They won't even have to go into the back room to deliberate. Find us not guilty. Have a nice day. See you later. That's how the system is supposed to work. And I love to see how that happen fully before I go out of here, whenever it is I do. I've got a while yet. But that's what I've been working for all the years I've been doing this. And now with the Supreme Court having our backs at long last, 90 years it's taken for them to act like a judicial court. And that's what's going to win things for us. Because the other side's going to know it. I'm going to bring it home in spades. And they're going to get the checkbooks out. Because they can't afford to go to a trial by jury and have me in there not only giving my testimony as an expert witness, but cross-examining them on the witness stand in front of an inflamed jury, unfiltered by one of their state bar association attorneys. It's not going to happen. That's how we beat the bastards. Now, that said, send me an email, uwinnincourt@gmail.com. Subscribe, like the videos, tell your friends. As soon as we cut out this divide and conquer crap they've been doing for way too long, the sooner we get the bastards off our backs. Thank you.